Rerenga Paraoa Marae whangarei, te paparahi o te raki, wiki rui te kaumā whā. Te ropu whakamana e te triti o Waitangi, te mana motake arohe o whangarei, iwa I tata, taino ki te lima kraka I te aihi, mane te kaumā iwa tai atu ki praere rui te kaumā toru. Tautoko, broadcasting live from Terenga Paraoa Marae, te paparahi o te raki, week 24, the Waitangi Tribunal Hearings Stage 2. Monday, 9 o'clock until Friday, 5 p.m, here with your Tribal Connection.
Ana te moana nui a ki wae. patu ake taku manawa, ka whakarangiru aku mahara. Au e tamakota aku aroha, ore rawa mutu mai. Wai ora mā te wā koto e tamama, e whakahoki mai. Ki awhi awhi atu taku ringa nei, e tōna piri ai. E patu patu ake taku manawa, ka whakarangiru aku mahara. Au e tamakota aku aroha, ore rawa mutu mai. Whakamoemiti, whakawhetai e hue. O au manakitanga, ki te iwi e tone. Ko koe, te piringa, ka putaki te oranga.
Spend some DOW and time. Wanna spend some downtime with you, baby, downtime. Wanna spend all of that DOW and time. Wanna spend some downtime with you, baby, downtime. I'm sitting here up in my room and I just cannot stop thinking about you. I can picture us KISSing and everything that lovers do. I wanna get to know you so I can get to hold you. Wanna start the waiting game. I'ma come over to you and ask you if you want to chill with me. Spend some quality. Maybe we could talk on the phone and wanna start to you. When can we spend some DOW and time? Wanna spend some downtime with you, baby, downtime. Wanna spend all of that DOW and time. Wanna spend some downtime with you, baby, downtime. I'm searching for a new boo and I hope that it's gonna be you. You're really ringing my bell and baby I can tell that you're really feeling me too. Come and get to know me so you can get to hold me. Oh, I'ma set the all on top. Name a time, name a date, name a place when you want to chill with me. Yeah, yeah. spend all of that. Let's spend some downtime with you, baby, downtime. We can drink some lemonade under that big old tree, or we can go downtown and watch a movie. Just spend time with me, baby, you will see. We'll be happy, so tell me where can we? Where can we spend some B-O-W time? Wanna spend some downtime with you, baby, downtime. Wanna spend all of that B-O-W time. Wanna spend some downtime with you, baby, downtime. I wanna spend some quality time with you, with you, with you. Oh, yeah.
Ai, tēnei te mi kona kia koutou te whanakona mai ki tēnei taonga o tātou mai te kanga nei ko te ringa Paraoa Marae mō rena tamari. Ngā mihi kia koutou noho mai nā i o koutou kangi tēnei rā. He rā hakamutuka tēnei mō te kaupapa nui I mua hoki a tātou ngā hapu me ngā whānau ngā pui araro hoki te kaupapa o te paparahi o te raki. Ko te wahanga rua te kaumā whā tēnei, ko te wiki rua te kaumā whā. Mai te timatanga o te wiki nei taino hoki ki tēnei wā, korongo tātou ki ngā kōrero mai ngā roia, a rātu ngā kai kōrero mō rātu ngā kai kreme, a rātu I tuku kōrero mua I te aroaro o te ropa whakamana I te triti o Waitangi mō te wahanga tuarua. Honi rā, ka mi ana hoki ke a koe, noho mai I tō kāngi, tēnei rā āhua pai. Ka whiti mai te rā kei kone ki a whangarei nei, me ngā tino kaupapa taino ki te kotai krakataihi nei. Welcome again to the last day of the Waitangi Tribunal Hearings, Te Paparahi o Te Raki, that's stage 2, week 24. We've been here for a week, and we're winding up today with the submissions from the Hokianga. This morning we've got the submissions from Ngāti Kiore Kotutaka, the First Nations people of Mangataupa, Mangamuka, Te Hutai, Te Karai and surrounding areas. Onero Piama is the first presenter, followed by Hori Chapman, who also will represent the Hapu Collective in the Mangamuka Te Karai area. Nō reira, always good to be in your whare, and again, hey, thanks for joining us today. To our many whanau living in many parts of the world, greetings from us here at Toru FM, Mauri tu, Mauri ora.
Three documents which can be attended to collectively this morning in the interest of time.
Yes.
Late yesterday afternoon, initially scheduled were Y1732 and Y2171. And I understand that with the assistance of Mr. Hockley, those two matters were brought forward or postponed until this morning due to a flood up at Mangataupa.
Yes.
To join with Y2072, and as I indicated, all three can be dealt with at the same time because there are some generic matters that pertain to all three.
279 and 280.
Yes, that's my understanding, sir.
Ka pai.
That said, at the appropriate time, each of those Y numbers with specific claim issues as they pertain to each of those will be addressed in due course. Nō reira I tēnei wā, I te tuatahi ki a koe te kaiwhakawā. Me koutou ngā mema o te tarai punara, kei te mihi ki a koutou. Me koutou ngā roe mo te karauna, me te rangatira, kei tō rāua taha. Te kaikawe kōrero mo te karauna, haramai nei tēnei ata me te wiki, kua pahuri aki nei kei te mihi ki a koutou hoki. I tēnei wā, e anga tōku aroaro ki te taumata, te paipai tapu o whangarei Terenga Paraoa, nā koutou I whakapua ki te tatau, mō tēnei kaupapa mō tēnei wiki. Nā koutou hoki I whakatakoto te whāriki aroha. Hei manaaki, hei tiaki, nei ngā kaikirime, e hara mai nei. Ko taimai a hokianga, I runga I te karanga o I nei ngā take, me ngā kirime kua takoto kei mua I te taraipunara nei. Nō reira kia kōroa kia koutou ngā rangatira o te marae nei, ngā ringa Raupā hoki kei Murira, I roto I te kihini, tēnā koutou, tēnā koutou, tēnā koutou katoa. Your Honour, I'm going to dive straight into it this morning and address some generic matters that pertain to all three claims. And where I can, I'll refer to those parts of the closing submissions where those matters arise. I'm going to start with reparations. In the relief and recommendations parts of each of the closing submissions, Your Honour, and the tribunal members, it talks about compensation. E rei wānanga, which was held recently, of the people of Hokianga, there was talk of the quantum of kauri and other native timber that had been removed from that area. There was talk of the value today in respect to that timber. Your Honour and the tribunal members, I would invite you to seriously consider requiring the Crown, by way of recommendation, to make reparations to the hapu and the people of Hokianga. Born out of the Northern War, born out of the attacks that were made on the sovereignty of the rangatira of Hokianga over time, and so on, all of which is articulated in more detail in the submissions. To give you all an example, which will be familiar to the tribunal, Japan and also Germany have been required to pay reparations for the instigation of wars which took place. Although I don't want to dive into the issues as to why that occurred, the submission for the claimants that I represent today is that the Northern War was instigated by the Crown, and therefore there should be reparations paid over time to the people of Hokianga. Going straight to the end, in the interest of time, also in the relief and recommendations sections of all three of the closing submissions that are before you today, there's reference there to exemplary findings. I would invite you, this tribunal, to consider, because of the Crown's behaviour, to use the words of one of the claimants who is seated to my right, Mr. Oniroa Pihema. The Crown should be punished for their behaviour from 1840 until today. Therefore, that should lead to the quantum of relief and compensation being determined based on that behaviour. Your Honour, obviously I'm speaking in general terms. All of those points are articulated in more detail in the closing submissions. There is also the special factor which is referred to in the relief and recommendation sections of those closing submissions. And that is, again, because of the behaviour of the Crown, that, and I touched on this earlier, the quantum of compensation should be assessed accordingly. Over the last day or two, the tribunal would have heard that Hokianga hapu or rangatira February 1840 had not ceded sovereignty, and we're grateful to the Stage 1 inquiry for their report, which records that and makes specific mention of Hokianga. It is the position of the claimants I represent, and no doubt this has been articulated by other lawyers and other claimants throughout the week, that Hokianga hapu have retained their sovereignty from February 1840 to today. It is rejected out of hand the position that the Crown takes, which is, and I think I might, just for the purposes of the record today, just quote the Crown's position on that. And it's articulated, as I recall, in the Crown Statement of Position and also concessions, where the Crown says, the Crown considered it necessary for Māori to recognise the Queen's sovereign authority over the whole or parts of New Zealand so that a settled form of civil government could be established. The rangatira who signed the treaty ceded without reservation all the rights and powers of whatever sovereignty they had. A discussion I've had with the claimants I represent is what would the North look like, particularly Hokianga, if Your Honour were to recommend and agree with me and other counsel that indeed Hokianga hapu have retained sovereignty to today. One practical example would be the issue of consultation. If that is the case, then in the performance of its kāwanatanga responsibility, the Crown, in instructing or directing its agent, the Far North District Council, would arrive at a hui with the hapu, but on the basis and with the premise in mind that the hapu have autonomy, that they don't have the resources to participate in the process, and they will be provided with those resources, that the role of the Crown at a local level will be to attend to and to look after the settlers, who are the farmers and Pākehā members of the community today, acknowledging, though, and continuing to protect the tūnaranga tiratanga of the hapu. It sounds outlandish that such a concept should be considered in 2017, but in my submission it's consistent with the view that indeed Hokianga hapu have retained their sovereignty and continue to do so today, sir.
Can you just help me here, Mr. Tupara, because you talk about exemplary findings, seeking compensation, and as I understood part of this, it's compensation for the Crown not protecting your claimant's sovereignty. But then how does that balance, if your starting point is that they retain the sovereignty that they have, and so they've never ceded it, so they've got their sovereignty, but you want compensation for the Crown taking their sovereignty. Can you, I'm in a bit of a dilemma there.
It's clearer than mud, Sue. The position is compensation is a reparation for the declaration of war against Hokianga hapu.
So it's not related.
It's not related to failing.
What about the special factor? Is that you talk about the special factor being part of the quantum or quantifying the amount of compensation or settlement, and that is due to the Crown's failure to protect Ngāti Kiore and
Te Kohatutaka
sovereignty.
That's a valid point, and it does not, I won't suggest that it compromises the issue of reparation and what that might look like, but certainly that would need to be addressed because it does lend itself to muddying the waters, as it were. So in short, sir, that would need to be addressed and worked through because it does contradict the concept of reparation based on declaration of war as opposed to seeking compensation for non-recognition and protection of tūnaranga tiratanga. So I take your point on that, sir.
And Mr. Tupara, did I understand that you're making a direct link between the removal of the Kauri forests and the failure of the Crown to protect that major resource and to ensure that Hokianga hapu receive the full value of the timber and the reparations that you're talking about?
I see both as being part of a package. The reparation component relates to, as I mentioned earlier, the Northern War. But as part of the package, there would be a component that refers to or relates to the extraction of kauri and other native timbers and the value that that might bring on today's market. So how could that be implemented? If this tribunal were to accept that Hokianga hapu have retained their sovereignty to today, in the relief and recommendations sections again of all three closing submissions, there's reference to the ability on the part of the Crown to implement constitutional change. There's two parts to that though. The Crown's responsibility to attend to the LAW and with the support of this tribunal to enable Hokianga hapu, based on tikanga, to reassert their sovereignty, tūnaranga tiratanga, over their whenua and their self-determination as a sovereign people going forward. Your Honour, those are specific comments or introduction points at this stage of a generic nature.
So how would you see that constitutional change developing? Because we've heard other comments this week seeking the same sort of thing in as far as going to not a local body but a hapu authority of some kind. At this stage, are you just calling for discussion to happen, or is there some plan of how that may be implemented on the ground?
There's a plan that's afoot now, Your Honour, and as part of the submissions today, an expression of that will be attended to. In short, the hapu who are represented in respect of these claims before you today, which are Ngāti Kiore, Te Kohatutaka, Te Ihutai, and Ōrira ki Te Ihutai, have reasserted their sovereignty and will continue to do so. In the closing submissions for all three Y numbers, there's reference to how they have expressed their sovereignty from 1840 to today and continue to maintain that authority, a chiefly authority handed down to them and to these descendants who are here with us today. I might go directly to an expression of how that could work today, Your Honour. I touched earlier on a general discussion around what consultation might look like. I want to go to acts of high treason that are referred to in the closing submissions for the Y1732 claim. And at the conclusion of those submissions relating to acts of high treason, Oniroa Pihemera is going to deliver a document in support of that. As this tribunal will be aware, high treason has been described and defined in different areas and in different places. The opportunity presented itself, however, to take or to adopt an extract from Dr. Ranginui Walker's book, Ka Whawhai Tonu Mātou. And I apologise, I thought I'd put the reference for that into the closing submissions as to the exact page, so I undertake to make sure the registrar gets that at some stage very soon, so I'd need to be reminded to do that though. And he described high treason as actual defiance of a government. It is my submission that in 1840, Hokianga Hapu had a government. In the Stage 1 report, there's mention of that. And it might be helpful if I actually quoted where there's reference to a government having been established or existing at that time. And I'll just quickly go to that now. Hopefully I'll find it quickly. I might instead go to one of the actual submissions. I'll go to Mr. Pihema's closing submissions, that might be easier, and I'll refer to the actual paragraph. And of course, the tribunal would have seen that his closing submissions are headed on the cover page, Crown Acts of High Treason. And I must say, that's not something that you haven't heard in this tribunal previously. It's certainly something that Mr. Pihema has ardently and fervently pronounced. On page 7 of the closing submissions, and I haven't made a note of that reference number, but it's for the Y1732 claim-specific closing submissions on page 7, paragraph 17. I'll read what I've got there. It is submitted that Ngāti Kiore and Te Kohatutaka had their own government in February 1840, given the following observation made by the Stage 1 Tribunal. Quote, Busby encountered a people who had their own systems of law and government which derived from whakapapa. Then over the page, paragraph 18, the Stage 1 Tribunal also observed that English text known as the Declaration of Independence of New Zealand contained 4 articles. In the first article of that text, the rangatira from the northern parts of New Zealand declared their independence and also asserted that their country was an independent state. In the second, they declared that all sovereign power and authority resided with them in their collective capacity, that they would not permit the existence of any lawmaking authority separate from themselves in their collective capacity, and that they would not permit any functions of government to be exercised except by people appointed by them and operating under the authority of their laws. And I go on to say, given those observations, it's clear Hokianga Hapu had their own government. Therefore, based on that premise from 1840 until today, any acts on the Crown in actual defiance of that government are acts of high treason. If we adopt Dr. Ranginui Walker's description. So what have those acts of high treason been? I'd start first of all with the Northern War. And I don't want to get into a treatise or a detailed discussion regarding the Northern War, other than to refer to the following. The Crown's provocative behaviour leading to the Northern War, other acts of actual defiance of Hokianga government, its attacks on Hokianga hapu sovereignty, which I touched on earlier, its imposed claims settlement policy, and of course this is not an exhaustive list, but these are matters or issues that have been raised by the Y1732 claimants. Governor Hobson's untrue proclamation, he iwi ko tahi tātou, the mistreatment of hapu maunga, awa and ngahere, and its racially biased education system. Each of those elements or components, along with many others which have been referred to throughout this inquiry over a lengthy period of time, in my submission, are evidence of actual defiance of a government that existed in 1840. And therefore, in doing so, the Crown committed high treason. As alluded to or referred to in the closing submissions for Y1732, this tribunal are invited to accept that there were acts of high treason, and on that basis to find that the principles of Te Tiriti o Waitangi were breached. I think with all due respect that goes without saying. Therefore, in the implementation of his tino rangatiratanga, and also as a descendant of those Hokianga rangatira who signed Te Tiriti o Waitangi at Mangungu in 1840, Mr. Pihema would now wishes to serve and execute a warrant to arrest on the Crown with a copy to the tribunal.
In order to pirangi mātou te hopu e nei kōrero, no reira kōrero ki te maikara, kia mau e nei kōrero mo ake tonu atu.
Ai, kia ora. Hara te mea nā ngāti kia ore kōtu taku tēnei, nā te mea i patua o tātou, i kohurutia o tātou mātou tupuna, mātou tatu mai tanga o te uwiki konei. E whānui ki atu te hauhunu tanga, te whānui titiro tanga o tēnei mea te high treason. E ki ene, nā te rino tuki ma te rino hono. Nā hoaino tēnei te rino te treason e whakahoki ana ki te karauna, o tēnā ki te kāwana tangarani. Mō rātou mahi i kohuru. I kohuri o tātou tupuna. I kohuru tia o tātou tupuna, nā. E haere mai rātou me te mata, me te pū. Nā, me te paipera. Nā, e tū nei ngā mihi nare, tū nei te kāwana tanga. E mahi nei ngā tore. A ki o tātou, mai rāna tatu maki tēnei wa. Nā koe e tēnei te kupu. Kehia rātou, e toru ngā hau tāma i takoto ai te treason. Ki Waitangi, ki Whirinaki, iai nei. Tani te mutunga. Anei, te hamane tanga iai nei. He tino hamane, me hamane, hako tēnei hari ki hea ko te teitei o teo ki te United Nations, te wahekoto, ka hari tonu. Nō tēnei, te kaipakawa, te raupu whakamana, te maturanga e kiri, i hena kia koutou. Nā te mea ka koutou, e raro tonu i te ngā kamana tapu o te Tiriti Waitangi i hari tia ira, rosi te waiwatanga o tātou mātou tupuna. Kei hea mā toto o tātou mātou tupuna i te whenua e tangi ake nei te tātou. Ko te whenua ke te mea nui. Nā, haere mai rā te tonga i te whenua ma ngā rawa kato, te whenua, nā reire tēnei. E tūne hu te rangatira tanga, te kaiwaka wā. Oe tēnei. E tūne atu kia
ngā kōtiro nei.
Ko kōtiro nei, kei ata ko hoa nuru.
Ko hoki e ki pōneke. Ko hoki e ki pōneke i rongo koe, i rongo ia kei ta haramai koe tēnei rangi. Matua, ko... Hoatu... Matua, onero...
Ai. Hoata ki a rātou.
Matua, onero, hoatu ki ngā kōtiro nei. Hoatu ki ngā kōtiro. Koina ngā roi o te karau nei tēnei wā.
Thank you, Matua. Noho mai konei, tēnei wā. Haramai, haramai.
Hobson said, "Ewi ko tahi tātou, how can we be one iwi?" That was the first violation of the Treaty of Waitangi. First violation. Ewi ko tahi tātou, how can we be ewi ko tahi tātou? Tātou kei te pēne, how can we? Tore tēnā me, kai ngā wā, tēnā koutu, i hana kia koutu. Tēnā tātou koutu.
To the tribunal members, in some respects, people looking in on this event today would ask the question, what is that? But in reality, he's exercising his sovereignty. And it's an example of what, for many years now, has been termed radicalism, and in many respects has been written off as being a farce, a laugh, not serious. Today, we've arrived, and we're very serious. That is a legitimate warrant to arrest served on the Crown in the exercise of hapu sovereignty. It's been done before. It's been done by the likes of Mr. Pihema and others even in this room before. The time has arrived, with all due respect for this Waitangi Tribunal, to support the hapu of the North who have now reasserted their sovereignty, which the Crown assumed it had acquired over time. The Crimes Act talks about high treason. There's opportunity to go to the United Nations, to the International Court and places like that. That's been tried before to confirm his tino rangatiratanga. This chief today is saying, no, why should I go overseas or go into, with all due respect, a European court and bring a private prosecution there? I'm going to, on behalf of my hapu, do what I'm about to do today. And I invite this tribunal to treat this very seriously, and I know you have. And to the Corona, although it's not for me to make submission to them, I pray and I hope that you'll take this seriously today as well, because you have been arrested. That completes, although there are other specific issues raised in the Y1732 closing submissions, that completes the more specific and more significant matter that is referred to in those submissions. I now move to Y2171. And again, I don't want to read from that document other than to highlight a number of key areas which have been highlighted by the claimants themselves.
What's the
document? And of course,
which document?
This is Y2171, perhaps, and that was due to be heard late yesterday afternoon, so I've missed that reference as well. I thought I had it in front of me.
3.3.280.
Yes, that sounds like it, sir. Thank you. And I simply want to highlight 3 or 4 key issues that are raised in those closing submissions to enhance the more generic matters that I've raised earlier. There's opposition to the Crown settlement policy. And the opposition is simply this. that if there is to be a settlement one day, it has to be a settlement with hokianga hapu, individual hapu, as opposed to ngā puhi whānui. In respect of these claimants, there's no opposition to settlement, but it's on that basis that that should occur. It's interesting how the cover sheet or cover page for those submissions sees it quite handsomely, the return of tāhaid whenua. The Treaty of Waitangi Act, as we all know, doesn't allow private land. Now, I'll use the words in the Act itself, the provision, the Crown does not have the ability to recommend the return of private land. Oh, beg your pardon, the Tribunal doesn't have the ability to do so. So it's statute barred, as it were. It does have the ability to have a discussion, to inquire into, and to make findings regarding that, though. And it's done so historically, and it's done so very well. In making findings broadly described as the land once belonged to the hapu, now it doesn't, and this is how they lost it, and in losing it, treaty principles were breached. In my submission, it's then incumbent on the Crown, in the exercise of good faith, and in the protection of not only Tino Rangatiratanga of hapu, but also their resources, to action that recommendation or finding. Beg your pardon, to action such a finding. I leave it at that. It's an interesting approach to things, but I'm sure the Crown shouldn't close the door on the fact that the Tribunal hasn't recommended the return of what is now private land. I've driven up from Auckland this morning and I've heard amazing feedback about the radio broadcast for these hearings. The irony is that the radio station has to pay for a license for the use of an aerial on Maunga Taniwha. And my submission shouldn't have to. Also, one of the claimants, and I'm sure he'd support me putting it this way, had to go back to school to not only learn his reo, but to learn about himself. And he incurred a student loan to do that. And I would submit that shouldn't have to happen. Not alluded to or referred to specifically in the closing submissions, but I understand there's dock land in the north. Already there is an abundance of whenua that could be returned to the hapu. And that includes Maunga Taniwha, I would submit.
So is Maunga Taniwha and dock, is dock have Maunga Taniwha at the moment?
Parts of it,
yeah.
Only, but that's not specific.
Somebody gave evidence on that, didn't they?
Yes, yeah. That's right. There is the Muri Whenua report, sir. A very early report, as you know, and it laid a foundation in terms of recommendations and findings, and it made it very clear, and again, this is not referred to in the actual written submissions, but it made it very clear, land that has been lost still belongs to the hapu. Hapu don't see that because they're no longer on their whenua, that somebody else has it, that they no longer own that. And I think that's a principle that has been espoused on more than one occasion, or a submission presented to this tribunal. Your Honour, I leave it at that in terms of why 2171.
Sorry, can you just explain that further? You mean in the sense that while hapu may not have title to a maunga, they still refer to it in their pepeha as their maunga. Is that what you're meaning, or?
They've retained a proprietary right based on tikanga mana whenua. Kia ora. Kia ora. That completes the more specific submissions other than what's already in writing for the Y2171 claim. I now go to the Y2072 claim, which was set down for first port of call, as it were, this morning.
That's 3.3.279.
Yes, I think I've got that one right, sir. Thank you. And this is a claim brought forward on behalf of Ōrira ki te ihutai. And again, supplementary to the more generic submissions that have been made earlier regarding reparations and so on, I wish to make more specific submissions regarding those particular claimants, if I can now. And I go directly to paragraph 29 of those submissions, where specific relief is sought. And it starts with, and this tribunal has already heard generic submissions on old land claims and scrip and so on. But there was, and it's not specifically referred to, as I recall in detail in the generic submissions, but there was the Marmon grant, M-A-R-M-O-N. And the loss of whenua incurred or suffered by the hapu, equating to some 1,500 acres, which is now in private ownership. And although, in inverted commas, validation occurred, the process was thwart, as you've heard generically, and breached treaty principle. There's also reference in paragraph 29 of those closing submissions to the Umawera Dam. As described in the closing submissions, it was agreed at the time that dam was installed, and it's more specifically and in more detail elaborated on in the brief of evidence that supports why this particular wine number, I should say. In short, it was agreed that water would be supplied not only to the dairy farmers, but to the Māori community, as it were, who were also farming. As things are today, the dam still exists, but water is not supplied to the papakainga. I've had the experience of walking the road taking me to the takutai moana of Ōrira, and in short, as referred to in the relief provision, there's a request that a road be constructed to minimise erosion in that particular area, simply because there is a wāhi tapu urupa there, and access legally is an issue, but also physical access remains an issue as well. That's known as the poieke wāhi tapu. There's also the Ōtariho block.
Sorry, what was that? Poieke.
Poieke, P-O-I-E-K-E. Now that wāhi tapu urupa is landlocked, and for the hapu to gain access to their urupa, they have or need to seek, which is obviously the case, permission to do so, and there are some issues there. And the evidence pertaining to that wāhi tapu is espoused or referred to in more detail in the brief of evidence that's on the record presently of Makarita Tito, Your Honour. There's also the Ōtariho Block 2B1B European title, which is what exists today, which was once whānau hapu whenua. And it's very much part and parcel, and understand Matua Pai Tahiri touched on Ōrira whenua and the loss of that whenua yesterday. And this is one of those blocks or areas. The matter of access, wharf access and so on for the people of Ōrira to those particular locations. In summary, to bring these submissions to a conclusion. And I started with the relief and recommendation sections, and for each of those closing submissions, recommendations are sought, and I won't read through those. The foundation, though, for those recommendations is really probably the nub of this tribunal in terms of where to from here for hapu, and I speak on behalf of representatives of Hokianga hapu, not all of them, and that is, Your Honour, for you to make a finding that Hokianga hapu have retained their sovereignty, for you and your tribunal have retained their sovereignty from 1840 to today, and to recommend to the Crown that they work with Hokianga hapu to put in place a process to ensure that hapu sovereignty is re-established, that they have retained and can reassert their self-determination and autonomy, and that the Crown, within the Hokianga, will exercise its kāwanatanga role, which it agreed to, as was found in the Stage 1 inquiry report, with the rangatira of the day, but at the same time protecting the tino rangatiratanga or chieftainship of the chiefs. Those are my submissions. Thank you, Sue.
Any questions? Thank you, Mr. Tupara, and thank you for summing up those three claims as one.
Thank you, Sue.
Tēnā koe. Tēnā koutou. Thank you, Mr. Tupara. Should have been an actor, should have been an actor. Ms. Patterson, you're here to present 3.3.254?
Yes, sir, that's correct.
Thank you.
May it please the Tribunal, Council's name is Ms Patterson and I appear with my learned senior Dr Gilling to present the closing submissions for Y1670. So I intend to provide a short summary of the closing submissions and then answer Tribunal questions. And just before I begin, I would like to acknowledge Mr Houghton for his recent nomination in the Matariki Awards for 2017 in the category of Hiwa Terenga Award for the Community for his services and achievement with He Korowai Trust.
Kia ora.
Y1670 is a claim by Mr Ricky Houghton on behalf of Te Patu and Te Uri o Rātama. The motivation for the filing of the claim was the way in which the Crown was conducting settlement negotiations and the threat this presented to Te Patu's sovereignty and identity. However, the claim itself is strongly focused on socio-economic issues, including health, housing, employment, domestic violence, and economic prosperity. The Tribunal heard extensive evidence from Mr Houghton during Hearing Week 18 of his experience with all these issues in both his personal capacity and through contact with clients of He Korowai Trust. The submissions begin with the issue of sovereignty and identity. Council submit that the Crown has breached Te Tiriti by not only failing to recognise Te Patu's sovereignty and identity, but actively damaging it. The evidence of the claimants is that the Crown does not recognise Te Patu as an independent and autonomous tribal group, and in fact has instituted a number of legal and policy mechanisms that have undermined Te Patu's sovereignty since the signing of Te Tiriti. These mechanisms are described at paragraphs 40 to 58 of the submissions. The next major issue for the claim is health. The claimants have a number of grievances under this heading, including the persecution of tohunga under the Tohunga Suppression Act, the institutionalisation of Māori in mental health facilities, mental health services, and the disparity in health outcomes between Māori and non-Māori. Council note paragraph 73 of the submissions, which state that Mr Houghton will be pursuing findings and redress on the issues of mental health and institutionalisation of Māori in mental health facilities and other tribunal inquiries. Thus, Council asks only for findings on the topics of tohunga and the disparity in health outcomes between Māori and non-Māori. On these issues, Council submit that the Crown has breached its Te Tiriti obligations, firstly to recognise and respect the traditional role of tohunga, and secondly to ensure a parity of health outcomes for Māori and non-Māori as promised under Article 3 of Te Tiriti. And these issues are discussed at paragraphs 64 to 72 of the submissions. A huge part of Mr Houghton's work through He Korowai Trust is providing housing services. This was the focus of his evidence to the Tribunal during Hearing Week 18. The grievances under this head include the Crown's contribution to the creation of housing inequalities between Māori and non-Māori, and the Crown's creation of barriers for Māori to access housing assistance. Mr Houghton provided information from He Korowai Trust's 2014 and 2015 annual report on the large housing need amongst his clients, as well as local and central government barriers he has encountered in trying to provide housing services. An example of this was the legislative changes to KiwiSaver that Mr Houghton initiated to enable KiwiSaver to be used on Māori land. Council submit that there is ample evidence for the Tribunal to find that the Crown has not met its Te Tiriti obligations under Article 3 in terms of providing equality of housing outcomes. The evidence on this issue is covered in paragraphs 84 to 136. Related to this issue are the grievances the claimants have with local government, including the lack of Māori involvement or representation on local government authorities, and the rules and regulations which hinder organisations trying to develop local housing solutions. In particular, Mr. Houghton provided detailed evidence of the barriers he faced while dealing with the Far North District Council and the Northern Regional Council in trying to develop housing in Kaitaia, described at paragraphs 151 to 158. Council submit that the behaviour of local authorities in this respect runs contradictory to the promise of partnership under Te Tiriti. On the issue of domestic violence, the claimants say that the Crown has not done enough to address the many issues which place pressure on Te Raki Māori whānau and which ultimately contribute to situations of domestic violence. Although this was not a specific issue for inquiry for the tribunal, Mr. Houghton provided evidence of this, summarised at paragraphs 164 to 171 of the submissions. The point of these anecdotes is to demonstrate the lack of services available for those struggling under financial pressure or trying to get away from domestic violence. Council submit if the Crown was meeting its more explicit duties under Te Tiriti in the areas of health, employment and housing, such instances of domestic violence would be greatly reduced. Finally, under the heading of economic prosperity, Council have submitted that the Crown has failed to meet its duty under Te Tiriti to ensure Te Raki Māori share equitably in economic opportunities in the region. The particular grievances of the claimants are the lack of economic development opportunities for Te Raki Māori, the lack of infrastructure in the region to support those opportunities, and the generally low income which many Te Raki Māori families must survive on. In 2016, Northland was still the most economically depressed region in New Zealand. As a predominantly Māori area, Council submit that such a situation cannot be congruent with the Crown's Te Tiriti responsibilities. The findings sought by the Y1670 claimants are set out at paragraph 210. Council respectfully draw the Tribunal's attention to findings C and E under the heading Sovereignty and Identity, which relate to the specific circumstances of the claimants, namely He Korowai Trust as an example of Te Pātu Tino Rangatiratanga. The remedies sought by the Y1670 claimants are set out at paragraph 211. The claimants accept that it is fiscally impossible to remedy the prejudices that Te Pātu and Te Raki Māori have suffered since the signing of Te Tiriti. Instead, Mr. Houghton has chosen to focus on practical recommendations that he believes would assist the Crown today to meet their Te Tiriti obligations. These recommendations are based on Mr. Houghton's on-the-ground experience over decades and are therefore well informed and likely to show practical results. Additionally, He Korowai Trust has a proven track record of being a very effective social service provider. Council respectfully draw the Tribunal's attention to letter E on page 83, which lists a number of remedies that are drawn by analogy from the Tribunal's Te Whānau o Waiparera Trust report, and which would fit equally well with He Korowai Trust. I want to give the last word in these submissions to Mr. Houghton himself and his hopes for the tribunal process. Te Pātu have lost so much. This has resulted in the hurt, the hate, and the harm that I deal with every day. We can and must heal ourselves, but we need a hand from the Crown to undo the harm of the past and support initiatives to provide a platform for the future. Council submit that the Tribunal should find the claimants deserving of that hand from the Crown.
Patterson. Just give us time to go through all our notes. Robin?
Tēnā koe, Ms. Patterson. I'm interested in this statement that the Crown has submerged Te Patu identity. And I think you're saying that this is historic as well as a modern policy
Yes.
outcome.
Yes. Yeah.
But when I look at what you've written here,